its electors to vote for the other candidate. Do you think the state has that power?
I think there may be principles that come into play in terms of after the people have voted that the state can't change the rules midstream. I'm not sure because I'm not aware of this court addressing it. And certainly as—
Well, let's change it so that it's not after the election. It's 3 days before the election based on the fact that the polls in that state look bad. Can they do it?
I think they probably could under this court's decision in Chafalo, where this court emphasized that for much of American history, state legislatures picked their own electors and assigned their own electors themselves. But of course, that would be much more extraordinary than what we have here, which is simple application of normal state ballot access principles to say that we're only going to put on the ballot an individual who is qualified to assume the office.
Could I ask you again the question that Justice Gorsuch asked, and to which you responded by citing the de facto officer doctrine? But suppose we look at that going forward rather than judging the validity of an act committed between the time when a president allegedly engages in an insurrection and the time when the president leaves office. During that interim period, would it be lawful for military commanders and other officers to disobey orders of the president in question?
I'm not sure that anything gives military officers the authority to adjudicate effectively the legality of the presidency.
Why not? Because you say he's disqualified from the moment it happens. Now, I understand the de facto officer doctrine might be used to prohibit people from seeking judicial remedies for decisions that take place after the date he was disqualified. But if he is in fact disqualified from that moment, why would anybody have to obey a direction from him?
Well, ultimately, there still has to be some kind of procedure in place to adjudicate the disqualification. Certainly, Congress could impeach a sitting president, but that's the only remedy I'm aware of that exists for removal or otherwise negating the authority of a sitting president.
Why? Well, on what theory? Because the Section 3 speaks about disqualification from holding office. You say he is disqualified from holding office from the moment it happens.
Correct, but nevertheless—
So it operates, you say that there's no legislation necessary. I thought that was the whole theory of your case. And no procedure necessary. It happens automatically.
Well, certainly you need a procedure in order to have any remedy to enforce the disqualification, which is different.
That's a whole separate question. That's the de facto doctrine. It doesn't work here. Okay, put that aside. He's disqualified from the moment, self-executing, done. And I would think that a person who would receive a direction from that person, the president, former president in your view, would be free to act as he or she wishes without regard to that individual.
I don't think so, because I think, again, the de facto officer doctrine would nevertheless come into play to say this is the—
No, de facto, that doesn't work, Mr. Murray, because de facto officer is to ratify the conduct that's done afterwards and insulate it from judicial review. Put that aside. I'm not going to say it again. Put it aside. Okay? I think Justice Alito's asking a very different question, a more pointed one, and more difficult one for you, I understand, but I think it deserves an answer. On your theory, would anything compel a lower official to obey an order from, in your view, the former president?
I'm imagining a situation where, for example, a former president was— a president was elected and they were 25 and they were ineligible to hold office, but nevertheless they were put into that office.
No, we're talking about Section 3. Please don't change the hypothetical, okay? Please don't change the hypothetical. I know I like doing it too, but please don't do it, okay?
Well, the point I'm trying to make is
he's disqualified from the moment he committed an insurrection, whoever it is, whichever party, that happens. Boom. It happened. What would compel— and I'm not going to say it again, so just try and answer the question. If you don't have an answer, fair enough, we'll move on. What would compel a lower official to obey an order from that individual?
Because ultimately we have statutes and rules requiring chains of command. The person is in the office, and even if they don't have the authority to hold the office, the only way to get someone out of the office of the presidency is impeachment. And so I think if you interpreted Section 3 in light of other provisions in the Constitution like impeachment, while they hold office, impeachment's the only way to validate that they don't have the ability to hold that office and should be removed.
Mr. Murray, can I just ask you about something Justice Kagan brought up earlier, which is the concern about uniformity and the lack thereof if states are permitted to enforce Section 3 in presidential elections. And I guess I didn't really understand your argument or your response to her about that.
Well, certainly, if Congress is concerned about uniformity, they can provide for legislation and they can preempt state legislation.
Yes, but you say that's not necessary.
But it's not necessary. In the absence of federal enforcement legislation, these questions come up to this court in the same way that other federal questions come up to this court, which is that a state adjudicates them. If the state hasn't provided sufficient process to comport with due process, a notice, and opportunity to be heard, one can make those challenges. But assuming, as here, we have a full evidentiary record, an opportunity to present evidence.
No, I understand that we could resolve it so that we have a uniform ultimate ruling on it. I guess my question is why the framers would have designed a system that could result in interim disuniformity in this way, where we have elections pending and different states suddenly saying you're eligible, you're not, on the basis of this kind of thing.
Well, what they were concerned most about was ensuring that insurrectionists and rebels don't hold office. And so once one understands the sort of imperative that they had to ensure that oath breakers wouldn't take office, it would be a little bit odd to say that states can't enforce it, that only the federal government can enforce it, and that Congress can essentially rip the heart out of Section 3 by a simple majority just by failing to pass enforcement legislation. Federalism creates redundancy. And here, the fact that states have the ability to enforce it as well, absent federal preemption, provides an additional layer of safeguards around what really